Hello and welcome to the Minimum Competence episode for Thursday, August 21st, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, DOJ's gender care probe, a legal privilege fight in Epic v. Apple, a TPS ruling, Musk's election giveaway lawsuit, and R&D tax breaks gone sideways. Let's remember, the crispness in the air is a whisper that summer has passed and something quieter is coming. And read today's legal news. On this day in legal history, August 21st, 1878, 75 lawyers convened in Saratoga Springs, New York, and formally established the American Bar Association, or ABA. Their shared aim was to advance the, quote, science of jurisprudence, promote uniform legislation, strengthen justice administration, uphold the profession's honor, and encourage collegial interaction among lawyers. Their organizing document, the original Constitution, still shapes the ABA's mission today. Over time, the ABA became the premier professional association for attorneys in the U.S., influencing national legal education, ethics, and law reform. It introduced the first national ethics code in 1908, the Canons of Professional Ethics, which eventually evolved into today's Model Rules of Professional Conduct. While the ABA once counted about 400,000 dues-paying members, by the low point of 2019, it had lost approximately 56,000 members, a symptom of shifting professional norms and changing perceptions of organizational value. Membership has continued to decline, with figures dropping as low as 227,000 by 2024. In response, the ABA has implemented membership reforms and reduced dues tiers to attract and re-engage lawyers, especially those early in their careers. The American Bar Association's recent actions reflect a mixed record in the face of escalating political pressure, particularly from the Trump administration and its allies. On one hand, the ABA has forcefully resisted efforts to erode legal independence. In 2025, it filed a federal lawsuit accusing the administration of intimidating law firms engaged in politically sensitive representation, and it criticized the DOJ's move to exclude the ABA from vetting judicial nominees as a blow to transparency and professionalism. It also defended its longstanding role in law school accreditation amid efforts to strip that authority. On the other hand, the ABA's decision in August of this year to eliminate 5 Board of Governors seats historically reserved for women, LGBTQ+ individuals, people with disabilities, and racial minorities marks a notable concession under pressure. The newly adopted policy opens these seats to anyone with a demonstrated commitment to diversity, regardless of their own demographic identity. While proponents framed the shift as a legal safeguard against lawsuits, critics viewed it as a capitulation, especially given the broader political context, including targeted attacks on ABA diversity programs and threats to its accreditation authority. The organization has also paused enforcement of its law school diversity standards until at least 2026. The Justice Department under the Trump administration has dramatically escalated its investigation into gender-affirming care, targeting the Children's Hospital of Philadelphia with a sweeping subpoena demanding detailed records, including names and social security numbers of patients who received such treatments. This move is part of a broader campaign to prosecute medical providers offering care to transgender youth, following a directive from Attorney General Pam Bondi to aggressively pursue these cases. The hospital pushed back against the subpoena, calling it an invasive overreach into a vulnerable population's privacy. In response, DOJ took the unusual step of asking the court to unseal the litigation, a departure from standard practice in sensitive investigations where proceedings are typically kept sealed to protect investigatory integrity. The judge sided with the DOJ, opening the docket earlier this month. The subpoena was signed by Brett Shumate, the newly confirmed head of DOJ's Civil Division, bypassing career officials who had refused to sign similar subpoenas due to ethical and legal concerns. Internal dissent had already emerged, with former officials warning that collecting such data lacked a strong legal basis, especially since off-label prescriptions like puberty blockers are not illegal under federal law. Critics say the investigation appears more performative than prosecutorial, designed to chill gender-affirming care through public pressure rather than build viable legal cases. The Trump administration has also directed other agencies, including HHS and the FTC, to scrutinize these practices, while states like Pennsylvania have filed lawsuits challenging the administration's actions. The outcome of the Philadelphia case, now in front of a federal judge, could shape how far the administration can go in turning gender-related healthcare into a legal battleground. A recent ruling in the Epic Games v. Apple case has sparked growing concern among corporate legal teams that the boundaries of attorney-client privilege, especially for in-house counsel, are being narrowed in ways that could harm innovation and compliance. The district court found Apple had improperly claimed privilege over documents that mixed legal advice with business guidance, drawing a sharp rebuke that, quote, adding a lawyer's name to a document does not create a privilege. That finding is now being appealed, with organizations like TechNet and the Association of Corporate Counsel, or ACC, warning that upholding the decision could upend how legal departments operate, particularly in fast-moving sectors like AI and cybersecurity, where legal and business decisions are tightly intertwined. In-house counsel argue they need flexibility to weigh legal risks within the real-world context of product development, market pressures, and regulatory uncertainty. At issue is the standard used to define privilege. The Ninth Circuit has previously backed the primary purpose test, which protects dual-purpose communications if a significant purpose was legal. But the district court's approach appeared more rigid, raising fears that companies will be discouraged from seeking or documenting legal guidance unless they rely on expensive outside counsel. Legal leaders say this shift would disproportionately impact smaller firms and startups already stretched very thin. They also point to a broader ambiguity across federal circuits regarding dual-purpose communications and argue that only a Supreme Court ruling can definitively resolve the inconsistencies. Oral arguments in the appeal are set for October 21st. A federal appeals court has allowed the Trump administration to move forward with ending deportation protections and work permits for over 60,000 immigrants from Honduras, Nicaragua, and Nepal. The Ninth Circuit Court of Appeals issued an unsigned order permitting the termination of temporary protected status, or TPS, for these groups while legal challenges continue. No legal reasoning was provided in the brief order. The decision lifts an earlier block by a federal district judge who had ruled that the move was likely driven by racial animus, violating constitutional protections. The new ruling immediately ends protections for Nepali nationals, with protections for Honduran and Nicaraguan immigrants set to expire by September 8th. The Department of Homeland Security praised the ruling as a step toward restoring the immigration system's integrity, arguing TPS has been misused as a backdoor form of asylum. Immigrant advocates, meanwhile, condemned the lack of explanation from the court and warned of serious humanitarian consequences for those now facing deportation to unstable regions. The case remains ongoing, but for now, thousands of individuals who have lived and worked legally in the U.S. for years are left in legal limbo. Elon Musk must face a lawsuit alleging he and his political action committee, America PAC, ran an illegal election year lottery disguised as a $1 million a day giveaway. A federal judge in Texas ruled that plaintiff Jacqueline McCafferty plausibly claimed Musk misled voters, particularly in battleground states, into signing a petition supporting the U.S. Constitution by offering what appeared to be a random chance at a $1 million prize. McCafferty alleges that, in exchange for signing, voters were required to provide personal data, names, addresses, phone numbers, and emails, which she claims were exploited for political targeting. Musk argued that the program was not a lottery because recipients were chosen to earn the funds and serve as America PAC spokespeople. But the judge pointed to conflicting language used in promotional materials, suggesting the money could be won, making it reasonable for voters to think it was a sweepstakes-style contest. Judge Robert Pittman, an Obama appointee, also rejected Musk's argument that voters suffered no harm, noting that expert testimony could establish the market value of political data collected during the promotion. The lawsuit, filed on Election Day of 2024, underscores growing concerns over the use of high-dollar giveaways in political campaigning and how voter data is gathered and deployed in swing states. Musk and his PAC have not yet commented on the ruling. And in a piece I wrote for Forbes earlier this week, the new One Big Beautiful Bill Act revives full expensing for U.S.-based research and development, a policy designed to encourage domestic innovation and hiring. At first glance, it seems like a major win for the tech sector and high-skilled job creation. But the labor market response reveals a deeper issue. You can't stimulate demand for talent without also addressing supply. With immigration pathways constrained and no meaningful expansion of domestic training infrastructure, the policy has triggered a spike in labor costs rather than a boom in innovation. In the absence of new talent pipelines, startups and tech firms are now paying steep premiums to hire U.S.-based engineers, effectively converting the R&D tax break into a subsidy for a tight labor market. Meanwhile, immigration policy remains restrictive and education-focused workforce solutions aren't being scaled fast enough to meet the moment. The result is a bottleneck, jobs going unfilled, innovation slowing, and companies forced to reconsider hiring or delay projects altogether. The piece argues that while R&D expensing is smart fiscal policy, it only works as part of a broader strategy that includes visa reform, immigration support for high-skilled workers, and real investments in domestic talent development. Without those pieces in place, we're left with a politically appealing tax tweak that, in practice, fails to deliver the innovation surge it promises. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, you can leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter form. We'll see you back here tomorrow, and until then, remember, you can feel the season changing in your lungs in the way the morning air forgives.